This just coming down, the state Supreme Court has just upheld its decision in the case of Arlene's Flowers, a Richland, Washington florist who refused to provide flowers for a same-sex wedding.
So Brandy's here to kind of break down this ruling for us. So what does this mean?
Yeah, so essentially what had happened here is the U.S. Supreme Court had a couple similar cases that were being thrown at it. You had a case in Richland of this florist who didn't want to provide flowers for a same-sex wedding. But at the same time, the Supreme Court had been handed a case involving a Colorado baker. So kind of same circumstances, just a different item for a wedding. So in this case, he didn't want to provide a cake for a same-sex wedding. So what happened is the Supreme Court took up that case of the Colorado baker, and they actually ruled a kind of narrow ruling, but in favor of the baker. So people had wondered, well, what's going to happen with the case of this Richland florist? Because the Richland florist lost her case in the Washington State Supreme Court, but the Colorado baker kind of won his case in the U.S. Supreme Court. So what had happened is the Supreme Court basically, it said, we're not going to rule on the Arlene's Flowers case, but we want the Washington State Supreme Court to go back and take another look at it. Look at our ruling in the case of the Colorado baker and decide if it changes your mind in the case of Arlene's Flowers. So what the state Supreme Court has decided today is that no, it doesn't change our mind. We have a different set of circumstances in this case of the florist from Richland, and so we stand by our original ruling that this florist violated Washington's Consumer Protection Act and the Washington law against discrimination when she said, I'm not going to provide flowers for that same-sex wedding.